Good afternoon, everybody. So today I'll be handling a session covering other aspects relating to negotiable instruments, including this aspect that is about the dishonor of checks, then other negotiable instruments, etc. Because there is a lot of coverage in relation to those items in the syllabus both for the LLB as well as for the LLM. So from that perspective, I will cover about negotiable instruments in this 1 hour session, basically dishonor of checks and other aspects also. So first, let me talk about the other instruments, because there is a reference in relation to this. A lot of items that are indicated in one of the syllabuses. So there are other instruments which are not negotiable instruments per se, but which are like negotiable instruments, about which I was referring to the other day. When in Negotiable Instruments Act, there are only 3 instruments that are indicated as negotiable instruments. One is promissory note, second is a bill of exchange, and third is a check. Now you have other instruments which have certain features of negotiable instruments, but which are not negotiable instruments per se. First of those instruments, and one of the important elements in relation to being negotiable instrument is the holder in due course will have a better title than the transferor. That is one element relating to negotiability. The second part of it is negotiation itself, the ability to transfer. That is an aspect that is also there. And the third thing is the protection which is available for these instruments, which are used by custom to continue to be used in trade without impinging upon the provisions of the Negotiable Instrument Act, provided there has to be usage. Where there is no usage, if you have a specific law, that law will apply. But where there has been a continuous usage, and if there is anything that is done in accordance with that usage is protected. So this is the principle. So while we have all these instruments, you will find out we will indicate, I'll indicate specifically what are the elements of negotiable instruments that are there, what is its nearness to the negotiable instrument, and what are the items that are missing. So those aspects I will cover. So first, the various types of instruments are hundis. Basically, these are traditional instruments which are used in the common market, sharafs and others used to deal in these hundis. So these are bills of exchange basically in local language, and they have been carried on for a lot of since quite some ancient time. And there are different categories of these institutions which you can relate to the various classifications of bills of exchange that we have discussed. The second thing is demand drafts or bank ultras. These are basically remittance instruments. Then third is dividend warrants. These are payment instruments of periodic amounts coming from corporates. Then the next is postal order or money order. These are again remittance instruments. Then traveler's checks. These are international instruments which are substitutes of cash. Then government promissory notes. These are basically notes issued against the public borrowings made by government. Then other instruments are fixed deposit receipts, which are savings instruments, life insurance policies, which are again property related instruments. Then share certificates, debentures, these are relating to the capital market. Then bills of lading, railway receipts, these are in relation to trade and movement of goods. Then circular notes, which are almost like your letters of credit or your traveler's checks. So first, let us see about hundi. Hundi is a bill of exchange in India in local language, and it has been in existence since ancient times. It is not a negotiable instrument act, not because it is a bill of exchange or something, but because there is a usage. And section 1 of the Negotiable Instrument Act says that Negotiable Instrument Act does not apply uh, where there is a local usage relating to instrument in local language. So if there is a local usage, then NI Act does not apply. But if there is no local usage, then provisions of Negotiable Instrument Act as applicable to bill of exchange will apply to these hundis also. Here the parties that are there, same as in a bill of exchange, you have a drawer, the one who is making the instrument or giving the order. means signing across. Then another person who is the drawee, that is the person who is supposed to make the payment. And the third person is the beneficiary who is the payee. The drawer or maker of this is a sharaf, is called as a sharafi or a nanavati. These are basically traditional bankers who are providing money. Then the payee who is receiving payments is he is going to get rich, so he is called as Rakhya Dhani. And a paid or cancelled hundi is called as khoka. That is, there is nothing in it. It's a empty instrument, empty thing, khoka. Then the different types of hundis are basically you have, I told you that bills of exchange could be payable on demand or payable on after sight. Then they are payable to bearer or they are payable to order. So all these classifications, and where there is a default in terms of making payment, then there is a payment acceptance for honor. So those elements which are there in bills of exchange, you can find it in these hundis also. The first, I will just rush through it. There is a Dekhandar or a Darshanhar instrument. So this is a hundi payable merely on presentation by anyone. So technically, it's a bearer instrument only. Then Namjogi instrument. So here it is payable to a party who is named or his order. So this is equivalent to your order instrument, and it cannot be further endorsed. That is, it is payable to him and him only. It's a conditional kind of an instrument which is payable to the party or his order only, and cannot be negotiated further. Then a Nisham Jog is a hundi payable only to the person who presents it. So it is a specific person only it is payable. That is, it's a kind of an order or a bearer instrument to a specific person. Then Shah Jog, it is payable only to a Shah. Shah is someone who is a respectable person in the locality, and it is not payable to the bearer. A Zikri chit. So this is a chit which is given by a person who is having some credibility. In case a chit, in case a particular hundi has been refused to be accepted or the payment of that hundi is unlikely, then this person who is respected, he will give a chit indicating that he accepts and he will pay he will pay the money at maturity. So in case the actual person to pay does not pay, then the person who has given the Zikri chit will be making the payment. It is as good as your acceptance for honor or something like that. So basically it is that kind of thing. Then Darshani hundi is basically, it's a hundi which is payable at sight and it is negotiable. So basically, whenever there is any amount, say it says pay to X rupees 1,000, and I will put my signature and I will direct someone to pay. So this is a title for money. So if someone wants to, maybe after say 1 month or 2 months, so if someone wants to get money today, what he will do is he will give it to someone else who presently does not need money, but who is interested in investing his money. So this person will take that particular hundi and then he will give it at a discount. So that is where 100 rupees are supposed to be received after 1 month, he will say that I will give you 99 rupees. So, or imagine that he finds that there are no better avenues to say, then he will say he'll pay, and if he thinks that he is going to get at a higher interest, then he will say he will pay it at a premium. So these are basically money market instruments. Hundis are and bills of exchange are money market instruments which are having a duration of less than 1 year. Money market instruments in the present financial market terminology is something which has a maturity not more than 1 year. So these instruments are basically discounted and they are passed on from one person to another. So they are negotiable. So they are sold at par. That is, if 100 rupees is there, 100 rupees is given. Then it is par. They are sold at discount, means they are for 100 rupees payment on X day, they will pay today 99 rupees. That is, they are paying at a discount or premium. That is, if 100 rupees is supposed to be received along with say 5% interest, they will pay it today take it at 101 rupees. So this kind of thing is very common as far as these Darshani type hundis are concerned. These are divided into two categories, that is Dhanjog hundi where it is payable to bearer, and Farman Jog where I will give a farman that it has to be paid to him. So it's basically a farman jog is an order instrument. Then The other type of hundi that is there is called as a miyadi or a muddati hundi. So this is something which is, these are, one is a demand kind of an instrument, payable on site, or it could be a time instrument also. This darshani hundi, it could be a time instrument also. In this muddati hundi, it will definitely be after a specified period, and banks grant loans on these hundis after deducting interest upfront. So these hundis are in turn divided into three types. Apart from Dhanjog and Farmanjog, which are bearer or order bills of exchange, you could have something called a jokhmi. Jokham means risk. So if you are transporting goods or shipping goods from one place to another, then there will be a risk relating to the vessel which is carrying your goods, and second, the risk in terms of your goods reaching there in proper shape. So for dealing with this only, the concept of insurance has come about, and for protecting against this jokham, the kind of instrument that is used is a muddati or a miyadi instrument. This is useful for providing the drawer funds and also serves as an insurance for risk of shipping goods. So if the goods are lost, the drawer is not liable. So there is a particular cost that is supposed to be borne for these kind of instruments. Then this is like your Jawabi Hundi is something which is like, it is used for remittance of money. So here the drawer, the party who is sending money, writes to the payee and delivers it as a letter to the bank. So he'll say, this particular banker, you pay him this particular amount, and I am going to provide. It's almost like a demand draft, but it happens through a letter. So the bank will say that okay, it will endorse it to the correspondent. So the letter will be issued to the bank also and to this person. The bank will find out who is the person who is nearer there, and he will endorse it to that person. And the payee will go and collect the money from that correspondent, either if it is a banker only or the correspondent of the banker, and he will receive that letter. And afterwards, that receipt of money will be passed on from the correspondent to the banker and ultimately to the party who is sending money. So this is the mechanism which is used in Jawabi Hundi. So basically it is an instrument of remittance using the bank and in the form of a letter. And either the bank or its correspondent will be making the payment to the payee at the place where he wants the money to be paid. The second kind of instruments which are almost quasi-negotiable instruments are your demand draft or a banker draft. So basically here, what is a demand draft? I go to Axis Bank Himayat Nagar and I want to make the payment to say DNS Law College, say Vizag. So what I do, I take a demand draft from Axis Bank saying that I will give him 1,000 rupees, saying that you pay DSNLU at Axis Bank Vijayawada. So here, what am I doing? Order is issued by Axis Bank Himayat Nagar to Axis Bank Vishakhapatnam to pay the amount to DNLSU, Damodaram Sanjeevaya Law University. So this is a certain sum of money again to the payee. The payee here is the law university. It is basically a demand instrument. So whenever this instrument is produced, the customer is supposed to be paid. This DD or a banker draft is used for remittance of money, and it is payable to the person or his order. It can't be a bearer instrument. So it has to be paid into the particular person only. It cannot be given to any person or any bearer. Then where a DD is endorsed by or on behalf of a payee, the bank is discharged by payment in due course. So it has a feature which is similar to check. Then demand draft, what are the legalities? Under section 13(1), a promissory note, bill of exchange or check is there, but DD is not included there. But in 85A and also based on subsequent court decisions, it has been made clear that a demand draft has all the characters of a bill of exchange and is an instrument. And if you see, the nature of instrument is also like a check. Okay. Then provisions of chapter relating to cross checks will apply in case of a draft also, as if it is a check. So it is basically a bill of exchange and a check combined together. In the form it is check, in terms of crossing it is like a check, and in the form of what is it, payment, etc., it's like a bill of exchange. So it's been indicated that it is like a negotiable instrument. The DD is not payable to bearer, and the prohibition that is applicable to promissory notes, bills of exchange, etc., is also applicable to demand draft. Under Section 31 of the Reserve Bank of India, nobody can issue a demand draft payable to the bearer because it will be as if it is a currency note only, as if it's a bank note. It is an order instrument and can be negotiated further unless it is crossed or made non-negotiable. What are the other aspects? Refusal of payment. There cannot be a refusal of payment in case of demand draft, provided it is given before validity by the person who is supposed to be receiving value to it. Stop payment. Payment because value is received before. I pay my money in Himayat Nagar before at Axis Bank, and the money to Damodaram Sanjeevaya College will be paid later. So because it is money is value received already, there cannot be a refusal for payment. Then stop payment. Payment cannot be stopped by purchaser as it is a commitment of bank in favor of the payee, except on title of a person presenting it. So if the person, if the payment is not going to be in due course by making payment to a person, then it can be stopped. Cancellation of DD. A purchaser can get the draft cancelled by the bank and not pay it before the draft is delivered to the payee. So I am posting it to Damodar at Visakhapatnam. Before it reaches there, if I realize that I should stop payment, I will give a request and the payment will be stopped. Otherwise, if it reaches Damodaram and they are receiving it, then it has to be paid. Then lost DD. In case the bank can exercise caution in making payment but cannot stop unless injunction from a competent court is received, because there is no mechanism of refusal of payment that is supposed to be made. However, if it is lost, a duplicate DD can be issued just like any other bill of exchange. Duplicate can be issued under Section 45A of the Negotiable Instruments Act. The purchaser or holder can apply and before maturity by giving a security indemnifying the bank. So once they are indemnified, loss is reported, then the paying branch checks whether it has been paid or not. If it is not paid, they will obtain an indemnity bond from the purchaser or holder, and then a duplicate draft will be issued. The next instrument is dividend or interest warrant. So what is this? Basically an order given by a company to the bankers, authorizing them to pay interest or dividend to bondholders or shareholders. If it is bond, it will be an interest-bearing instrument. If it is a share and the company makes profit, that profit is distributed among its shareholders by issue of dividend warrants. So these are basically the bankers of the company will be giving instruments, and if they are presented, they are supposed to be signed by the shareholder or the debenture holder. If it is a shareholder, then one of the shareholders, if he signs, that is enough. If it is an interest warrant bondholder, then all the persons have to be signing at the respective place which is provided for in the warrant. And if it is signed, then they will be paid. The validity of these instruments is 3 months, and they are issued in a form which is similar to checks, and they are treated as checks. If you see, this was a part of at par clearing, and because these instruments were more, now the payment of interest and dividend is by and large done through electronic clearing service. So demat accounts are there and other things. So the use of dividend and interest warrants has come down drastically. Then the next instrument is postal or money order. These are basically instruments of remittance, facilities provided by the Department of Post to facilitate payments. So it is ordered by one post office which receives money from the purchaser to pay to another office, another post office, to pay the amount to the specified person. If it is a pay order, to whom the money is supposed to be paid is specified. To that person it is supposed to pay. Or a money order, it is indicated that say X will be the beneficiary. So against the customer's signature, the amount will be paid. These instruments could also be collected through the banks, but generally banks don't collect it. They are reluctant because there is no protection which is available for the collecting banker, and as they are not covered under the Negotiable Instruments Act. Then traveler's checks, basically I have to travel to US. I don't want to take cash. So what I do is I go to a American Express or some ICICI bank, and I will deposit the amount with them, and I will say that you issue me the traveler's checks of say $100, about 10 checks. So what they will do is they will take an application and they will have standard formats of traveler's checks. So they will give me 10 $100 traveler's checks, and on the check I will have to put my signature. So tomorrow when I go to US and I want money, then I will go to that particular facility where these checks can be encashed. There I will again sign, and they will verify my signature with this, and then they will make the payment to me in dollars there. So this is an instrument of substitute of cash through an instrument, a standard instrument. There is no time limit for encashment. If I am not able to get spend all that, I can bring that, hold it here, depending upon the foreign exchange rules. And they are similar to checks in many ways. Then, in case I lose these checks, what is the provision that is available? So only when the signature is properly there, the person will be paid. But if the signature is not matched, then the bank will be liable. If the signature is very similar, then they will not be held liable. But I can record a stop saying that I lost these traveler's checks, then they will flash this message of my loss of those numbers to all. And before making payment, the bank is supposed to check whether there is any stop which is recorded against this instrument. This is as far as traveler's check is concerned. Government promissory notes, basically, government borrows money from public for taking up various developmental activities. That public borrowing could be in the form of promissory notes, could be in the form of government stock, it could be in the form of ledger balances in accounts, just like your bank account, a demat account of government securities. So promissory note, stock, and SGL, subsidiary general ledger account, were the popular forms. Apart from that, there were bearer bonds, but that was very rare kind of issues. So these promissory notes were issued. If it is a state government loan, then the governor promises to pay this much amount on this particular day at this particular rate of interest, depending upon the amount that you have subscribed to the loan. If it is a central government loan, then president promises to pay. So the problem with these notes were that if they are lost, there is a very cumbersome procedure. These notes are transferable by endorsement and delivery. There will be endorsement cages in the reverse of the promissory note, so they will be signed and they will be transferred. So periodic interest to be paid, the holder is supposed to bring that instrument to Reserve Bank of India, and then it will be checked, and then they will be making the payment. So interest payment, there will be interest cages on this instrument. So if it is lost, then it is very difficult to issue a duplicate note. So you have to give press publication, etc. And it's a very time-consuming task and a very difficult process. So to do away with it, what central government and state governments and RBI have done, because RBI is the public debt manager of government, state and central. So it indicated that we will stop issuing promissory notes in 90s. Now whatever is issued as stock, and it could be held in the bond ledger account, could be in the subsidiary general ledger account, or it could be issued as stock certificates. Stock certificates are different because the ownership is maintained in the register with Reserve Bank of India. That gives you title. But in case of a promissory note, your physical holding of an endorsed and delivered instrument gives you title to that money that is there in the note. So these are presently the only instruments which are issued as government promissory notes are Government of India Treasury bills, which are issued as a 91 days, 182 days, 364 days, etc. They're issued by Reserve Bank of India. The transferability, these are not governed by the Negotiable Instruments Act, but they are governed by the Government Securities Act and Government Securities Regulation. As I told you, these promissory notes are transferable by endorsement and delivery. Then the other kinds of instruments which are there are fixed deposit receipts. So you could have receipts. These are receipts which are indicating holding of fixed deposits in a bank. They are not negotiable as they cannot be transferred. You cannot transfer from one person to another. So there is no negotiability. There is no transferability, leave out negotiability. Then in case of LIC policies, they are not negotiable instruments, but they can be transferred by endorsement and delivery. But the problem is that the receiver, the transferee, will not receive a better title than the transferor. So that element of negotiable instruments, where the holder gets a better title, holder in due course gets a better title than the holder, that will not apply in case of life insurance policies. Share certificates, they are not negotiable instruments. They are just like any other property. They cannot transfer of a better title. It's not possible. Debentures, while share certificates are contributions to capital, debentures are contributions in the form of loan. So they are instruments of borrowing. These are share certificates are instruments of investment. The share certificate, the debentures could be convertible to shares or not. Only a bearer instrument is like a promissory note, but you don't generally have this bearer debenture. The other important things are bills of lading. The bills of lading are basically they are evidence of putting your goods on ship for export or import, depending upon which side you are dealing with. So these are documents of title relating to the goods which are shipped. That way, bills of lading. Same is the case with railway receipt. You are putting the goods and sending it through railway. The evidence of sending it is your railway receipt. So they are not negotiable instruments. They can be transferred. A bill of lading can be transferred by endorsement and delivery. But the title better than the transferee, than the transferor is not possible like in case of negotiable instrument. In case of railway receipt, they are freely transferable. But the Supreme Court held that they cannot give a better title to the transferor like in case of a negotiable instrument. Circular note, basically it is a request issued by banks to its correspondents abroad to pay persons traveling abroad specified amount issuing a letter of identification. So in traveler's check, you are having an instrument of the bank. Here you are having a letter or a note. And with this note and letter of undertaking, identification, he will put his signature across. He would have signed at the bank. Then he will go and sign there abroad in the place where he wants to receive money. Again, after tallying this, the money is paid. So in a way, it is like a letter of credit or like a traveler's check. So these are the various kinds of instruments which are like negotiable instruments. So now another important aspect that needs to be learned as far as negotiable instruments act is the parties, because holder in due course, etc. will become important. So I will just run through the parties. Most of these we have already dealt. I will go through specifically about holder in due course, etc. The maker, basically anyone who makes a negotiable instrument, but this is used generally for a promissory note. In case of a bill of exchange, whoever makes it or a check, he is called a drawer. Then drawee, the person who is directed to pay the money is the drawee. In case of a bill of exchange or a check. In case of a check is a bill of exchange where the drawee is a banker. Then drawee in case of need. So I am indicating one person. Then I am also indicating in case of need, you can get money. What is it? Instead of X, Y can also pay. So if X pays, then okay. If X does not pay, then Y pays. So this is in case of need. An additional person in bill of exchange or endorsement. Either it can be on the instrument or at the time of endorsing, I can indicate that there will be another person who will be a drawee in need. Then acceptor. A bill of exchange needs acceptance. But acceptance is not necessary in case of a promissory note. Acceptor is the person who accepts a bill of exchange by signing his assent for payment. Then acceptance for honor. The person who accepts a bill of exchange has not been accepted or has been dishonored by the person who is supposed to be drawee. Then there is I will go and approach another person, and this other person says, yes, for maintaining the honor of the person who is supposed to pay, I will accept the instrument. So this person who is doing it is called as an acceptor for honor. Or I may have an impression that this person who is originally supposed to pay, he may not pay. So in which case I will insist on ask for a better security for honor of the drawer or endorser. In which case he will become the acceptor for honor. Payee, basically the person named in a promissory note or a bill of exchange for or a check to receive the amount of an instrument. Endorser, because these instruments are negotiable and the negotiability of order instruments is through endorsement and delivery, the person who is making the endorsement, not as a drawer or a maker, he is called as an endorser. He puts his signature and say pay to X or pay dash. If it is he's converting he's making a blank endorsement. then he will say pay dash, and he will put his signature. This is the person who is doing this is an endorser, and the person to whom delivery is given after endorsement is the endorsee. He will be the person in favor of whom the endorsement is made. Then the three other important items are holder, holder in due course, and holder for value. So what are these parties? First, holder. Section 8 says any person holding a negotiable instrument who is entitled to possession of the negotiable instrument in his own name. That is, he is entitled to hold the instrument in his name. Second, he is entitled to receive or recover amount of negotiable instrument from parties in his. So, if these two conditions are met, then the person will become a holder, and it includes an original payee. And after the negotiable instrument, if it is negotiated, if it is a bearer instrument, the bearer will be the holder. If it is a order instrument, then the endorsee will be the holder. But holder in due course is something more than a holder. Any person who is a holder in due course, section 9 says that any person who, for consideration, becomes the possessor of a negotiable instrument, if it is a negotiable instrument payable to bearer, or he is the payee or endorsee if the instrument is payable to order, before the amount mentioned in the negotiable instrument becomes payable, that is, before the maturity of the negotiable instrument, he comes into possession of that instrument, and he has no cause to believe that there existed any defect in the title of the person who gave him this instrument or who negotiated this instrument with him. So he gives consideration, he takes possession of the instrument, then the instrument's possession is taken before the maturity period, and he is on a bona fide belief that everything is fine, the title of the person who has given it for consideration. Then what is holder for value? So if at any point of time value has been paid in relation to an instrument, then that instrument, whoever is holding subsequently, will become a holder for value. Imagine that I want to buy a mobile phone, I go to a shop and I give him a check. Then the shopwala gives this money as a gift to his employee. So I have already paid value for the instrument. So this person who is now receiving it as a gift, he has not paid anything. So, but I have given it as a value for giving the instrument. So this instrument, which is held by the person who has received it in gift, will become a holder for value. He cannot be called a holder in due course because there is no consideration in this gifting. Then a receiver of checks. Subsequently, in case of a banker, so imagine what banks do is, if they are having faith in the customers or if their accounts are generally good, what they will do is they will give credit even before the proceeds are received. So I will deposit a check into the bank. Immediately I will get the amount of the instrument, and I will be permitted sometimes to draw on that instrument also. So where I am not getting money, but I am getting credit into my account, to that extent of that instrument, the banker will be the holder for value. It is an arrangement which they do. So sometimes what they do is, I issue a check, they will adjust the amount in the OD account. They would not have received money, but it is a trust which they have or repose in me. So to the extent that they have provided credit to the overdraft or provided me funds into my account, they are holders for value. Then right of the holder, he can convert a blank endorsement to full endorsement. So he can cross the instrument after issue. Then he is entitled to duplicate in case of a loss of a bill, section 45A. Then he can negotiate the instrument to a third party. Then he can present it to the drawer or maker for getting back money. He has a right to sue in his own name because he is entitled to possession of the instrument in his own name. Then he is entitled to receive money in respect of the instrument. So he has a right to sue in his own name, and he has a right to use the instrument in his own name. Okay. So these are rights of the holder. So for a holder to be holder in due course, what are the conditions? Conditions: one, lawful consideration. That is, it should not be a mere gift of an instrument does not make the person who is receiving the gift a holder in due course, because there is no consideration. Second, if the consideration is forbidden or prohibited under law, fraudulent, immoral, or opposed to public policy, then that instrument, it is not lawful consideration, so he won't be a holder in due course. Suppose he is transporting, giving drugs, and for selling drugs he receives instrument, then there is no, the consideration that is there is drugs and money for drugs. So this cannot be a lawful consideration. So it will not be, he will not be a holder in due course. Then if the consideration could be inadequate, so maybe I am giving 100 rupees, but I am giving 1,000 rupee check. So in this particular case, I will have option to be a holder in due course to the extent of value of consideration or to the value as determined by a court. So that will be a matter of dispute. Okay. In a matter of dispute whether I will be a holder in due course or not, in inadequate consideration, I can be a holder in due course to the extent of value as consideration or as determined by the court. The instrument has to be received before maturity. If the instrument is taken after the maturity, I will have the same rights as a holder. I cannot have a better title as I would be getting in case I am a holder in due course. Then it must be a complete and regular instrument. So imagine that the instrument should not have any material defects, and it should not be an inchoate instrument. That is, imagine there is an instrument and it is no amount is written. So I will fill the amount of 1,000 rupees and I will hand it over to you. So at the original stage when it is supposed to be intended, maybe he didn't intend to be used for 1,000 rupees. In this case, the person who is receiving it after filling of 1,000 rupees, he will be only a holder. But imagine if further for consideration transfer this instrument to someone else. The person who is now receiving a filled inchoate instrument received by a holder, that fellow will become a holder in due course. But the person who is receiving first after the filling in the details will not be a holder in due course. So an incomplete instrument, he will not be a holder in due course. Then good faith, he must take the instrument without sufficient notice to believe if any defect existed in title from whom it has been received. So there's no indication of good faith in the system, but the section says that he should have received it without sufficient notice to believe that there is any title defect of the person who has given him this instrument. The subjective or objective good faith, that is, whether he has acted honestly, or we're noting whether there are any circumstances which led to a doubt or suspicion about the title of the holder. If these conditions are met, he becomes a holder in due course. What is the impact of defective title? This is discussed in section 58. So where the instrument is a defective title is if someone steals the instrument, or someone who has found the instrument, or if the instrument is obtained by fraud, if the instrument is obtained by unlawful means like coercion, undue influence, etc., then if he obtains the instrument for unlawful consideration. So in all these cases, the title is defective. If this kind of an instrument is transferred to someone, to a holder, that is not for consideration, then the holder will have a defective title only. But if this has been transferred for consideration and in good faith and before maturity, the person will become a holder in due course and he will have a valid title. The only case where the defect will continue is if the instrument is forged. Why here? Because in this particular case, a forged instrument does not give title to anybody. So if there is no title, better title of no title is no title only. So the holder in due course does not get any title. So let us just run through quickly what are the various privileges of holder in due course. One, there is a presumption under section 118 which I already discussed, that every holder is presumed to be holder in due course. Then privilege against inchoate stamped negotiable instrument transferred to him if complete as per section 20. Even if it exceeds value. Suppose I am thinking that it has to be 1,000 rupees. As I told you earlier, I wanted to have the instrument for 1,000 rupees, but I didn't fill it, and I gave it to X. X puts in, say, 1,500 rupees on it, and then stamps it appropriately and hands it over to Y. Then Y in turn transfers it to Z for consideration. So Z will have the privilege against an inchoate stamped instrument. He will become a holder in due course, even if the value exceeds. Then does not exclude liability to HTC, even if drawer or payer of negotiable instrument are fictitious, provided he has signed in the same handwriting. Suppose I say, instead of Mallikarjun giving a check, I will an instrument. I will say I am Amitabh Bachchan, and I will put my signature as a drawer. Then I will again I will indicate that pay to Jaya Bachchan, and someone else will sign as Jaya Bachchan, and he will mark it on to say Abhishek Bachchan. So if the signatures are tallying, then it doesn't matter whether this Amitabh Bachchan, Jaya Bachchan exist or not. So anyone who is subsequently getting this instrument, he will be it does not exclude liability to keep. The other persons will be liable to the holder in due course in case the payment is not made. The only requirement is in the chain, the signatures should be tallying, and then further ahead. So everyone else who is behind the holder in due course, they will be liable to the holder in due course. Then prior defects do not affect the title. That is the advantage of negotiable instrument. The holder in due course, if there is any previous title, he will get a better title. So the defects will be taken off unless it is a forged instrument. Then endorsee of a holder in due course has rights of a holder in due course. So naturally, he is having a good title, he will pass on a good title only to the next person. Okay. Entitled to recover amount from transferor or any or all of the previous parties, except if party to fraud. So there is no good faith, so he cannot recover. But otherwise, he can recover from the previous party or the previous or all the previous parties before. Then party is liable if negotiated to holder in due course by delivery, even if it was a conditional or for specific purpose. So if there is a conditional transfer and it was transferred to a holder in due course for consideration, then irrespective of the condition, he will be in a position to make the other parties liable. They cannot say that this condition was there, but in spite of that it was transferred. That kind of arguments will not go. Then maker and of a promissory note and drawer of bill of exchange or acceptor is estopped from denying original validity of instruments. So we talked about estoppel while we talked about specifics of presumptions and special features of negotiable instruments. One is a maker or of a promissory note or a drawer of bill of exchange or an acceptor. He cannot say that the original validity of instrument he cannot deny, because if he is denying, then he should not have passed it further. Then he cannot say that the payee did the capacity to endorse the promissory note bill of exchange. He did not have capacity. Then why did you take and then why did you pass on? That is the logic which is there in this. Then the endorser is estopped from denying the signature of a prior party. So if you deny, then why did you pass it on? The same logic will be applied. And these are very important principles for the simple reason that if these presumptions and principles are not there, financial transactions becomes very difficult, and financial transactions are the essence of modern day human living. So to facilitate that, Negotiable Instruments Act came in, and the provisions are all intended to ensure smoothing of the process. So if I am going to and build trust, and this trust is built through the provisions relating to giving it to holder in due course, etc. This is all the concept of Negotiable Instruments Act, and especially the rights and privileges of a holder in due course. These are already dealt with, rights and duties of a holder in due course. Then capacity, a negotiable instrument is as much as a contract. So the capacity of the parties is also very important. So what are the special kinds of parties that are there? The parties should be eligible to contract, because only then they, being negotiable instrument also being similar to a contract, they should be eligible to contract. A minor cannot make a promissory note because he cannot be made liable. Even he may draw, endorse, or deliver a negotiable instrument to bind everyone, but he cannot bind himself. because a minor is a protected person or a protected entity. Similar benefits of he can be a payer, he can be a holder, and he can sue other parties. Similarly, a guardian cannot bind a minor, though he has done something for his benefit. As far as a corporation is concerned, its capacity depends upon the memorandum and articles of association of a particular corporation or a company. As far as a lunatic, drunken person or a person incapable of understanding effect of the contract, he is treated similar to a minor. Insolvents, the property including negotiable instruments pass on to the official assignee or the receiver. It is treated as if this is the whole estate which is there for distribution to the creditors. That way, insolvents, the NIs, the negotiable instruments, pass on to the official assignee or receiver. In case of married women, nothing special. They are as capable as other parties. In case of agent, they are capable of handling negotiable instruments to the extent of authority given by the principal. If they are not indicating that they are acting as agents, then the agent will be personally liable for the instruments and whatever he does with these instruments. In case of a Hindu undivided family, they act through the Karta, who acts as a principal of the HUF and not as the agent of HUF. And legal representatives, they will fill into the person, heirs, executors, administrators. Now, next important aspect that we need to see is crossing of checks. This is also something which is very important. Section 123 and 124 deal with crossing. So I will just read through this section and we will see what are the samples of this checks. A check can be crossed generally or specifically. The general crossing is discussed in section 123. Special crossing is discussed in section 124. So where a check bears across its face an addition of the words "and company" or any abbreviation thereof between two parallel transverse lines or of two transverse lines simply. So it could be you have two parallel lines, transverse lines, or two parallel transverse lines and company written or and co written in between. Then that addition they can write with or without not negotiable words. So they could write and co, not negotiable, or simply draw two lines and say not negotiable. So this way the instrument is treated to be generally crossed because there is no specific person to whom it is marked. In case of special crossing, 124 says, where a check bears across its face an addition of the name of a banker, either with or without the words not negotiable. So here you don't find between two parallel transverse lines. It is not necessary that you should drop transverse lines at all. You merely write the name of a banker. Automatically, it will be treated as specially crossed. Then it will be deemed to be specially crossed and to be crossed to that banker. So it is specially crossed and crossed to that banker whose name you are writing across the instrument. So the crossing essentials and types. So how to cross? In case of general crossing, drawing two lines, parallel, straight, and transverse. That is sufficient for general crossing. In case of special crossing, that is also not necessary. It has to be across the face of the check. The general thing is that you are doing it on the left hand top corner, and generally it is done once, but in case of double crossing, there will be two crossings, one in favor of the banker, second in favor of another banker who is supposed to be the agent for collection of money on behalf of this banker. So this is called as second special crossing or double crossing. So this is generally in cases where you have a banker who is not a clearinghouse member, but who is a sub-member of a clearinghouse member. So what he will do is he cannot collect the money. He will authorize someone else, another banker, to be collecting money on his behalf. So he will cross to that and tender the check. So that bank will go to the clearinghouse, collect money, and then credit the account of this bank for credit to this customer. Then crossing of a check is also a material part. So if any modification, crossing is removed, crossing is taken off, etc., it will be treated as a material alteration of the check, and protection and other things will have to be accordingly seen. Then who can cross? A drawer of a check can cross, a holder of a check, or a banker. All the three. Banker only he can do double crossing also. Then types of crossings, you have general crossing if nothing is written, or and company, or and abbreviated form of company, not negotiable, is written between the lines. Special crossing, if name of banker is written between the lines, and not negotiable, is it written or not written. Then double crossing and second special crossing. Here the name of another bank is written. The general crossing, so here it is, the first one is, this is a normal crossing that you make. This is an and company crossing that you make. Then here, full name, this is an abbreviated one. The more popular one is right crossing and then right account payee. This account payee you see is not provided for in section 123 or 124. It is, but it is by practice it is coming. So the crossed check is supposed to be collected into the particular account of the person. Then this not negotiable is another mechanism of crossing. So you can write and company and not negotiable also. So this does not take away the transferability of the check, but only gives the person who is receiving the check an equal title on par with the transferor. So he will not be getting a better title than the transferor. Special crossing, here I am indicating HDFC Bank, then HDFC Bank not negotiable. So I can include not negotiable, I can include negotiable. So here the presenting should be done only to, payment should be made by ICICI Bank only to HDFC Bank. This is the meaning of special crossing. Then double crossing. So imagine the PMC Bank is there and it's not a clearinghouse member. On the reverse of the check, PMC, generally that is how it is written. You don't write again on the top of the check. They will write on the reverse, stamp on the reverse saying that pay to State Bank of India as agent for collection for PMC Bank. And this will go to the clearinghouse. Money of this check will come to SBI and SBI will in turn credit the money to PMC Bank. So what are the effects of crossing? Basically, the direction of payment is modified by crossing. What if I am saying using a general crossing, it has to be paid only to that bank, to a banker. If I am making a special crossing, the specified banker only the payment is supposed to be made. So by putting these cross lines, I am directing the banker to make payment to the account holder and not across the counter. In case I am writing the specific bank, that pay to this bank and not any other bank. So this provides, what is the benefit of it? It provides protection from fraud and misappropriation or misuse by not paying across the counter or by paying only to a specified banker. If it is not presented by banker specified, then the check will be returned. Then crossing does not affect the transferability. So it can keep, you can endorse and deliver it, and it can continue to keep transferred and negotiated as well. But where you are putting a cross and writing not negotiable across it, it does not make the check non-transferable, but it is not negotiable in the sense that the title that the transferee gets is not better than the title of the transfer. And it is an indication to someone that I don't intend this to be transferred further, but I am expecting that this person only is good. So whoever is receiving a non-negotiable check has to be on guard, because he is not going to have the protection of a holder in due course. That is why this non-negotiable crossing is done. Then banker's liability. So if in spite of the crossing, a banker pays over the counter or collects for a wrong bank, then the payment is not in due course, then it constitutes a breach of customer's mandate. Then the bank is liable to drawer for any loss that is likely. Then bank is liable to the true owner, who could be a third party with relation to the bank. The check clearing process becomes very important here, because this is the way in which the instruments will go. First, presenting banker or collecting banker, then the paying banker. So imagine that I am having the previous check, that is an ICICI Bank check. So if I am giving it to my brother, okay, say Siva, or say Siva, then Siva goes to ICICI Bank and collects money across the counter. So in which case, what is happening? I am the paying banker. Okay, ICICI Bank is the paying banker. There is no need for collection. In this particular case, Siva has to go to ICICI Bank, put his signature, received money, and sign across it, show identification. Then he will be paid the amount. Then he can go off. If I am crossing the check, then Siva cannot go to the branch and collect money. The bank, if it pays, then it will be liable. And what the bank will say is, it will say, he will return the check saying that it is not appropriate. It has to be coming for collection only. So now you have another bank which is coming. Imagine that Siva also has an account with ICICI Bank. Then he will say it will be a transfer transaction. There will not be a different banker which will be coming in. But imagine that Siva has got an account with HDFC Bank. So now what he will do? He will deposit this instrument along with a pay-in slip to HDFC Bank. So HDFC Bank will send the check for clearing, and the check will reach ICICI Bank. So here you have different parties which are coming. So what are these parties? You have a presenting bank or a collecting banker. So here Siva's banker, that is HDFC Bank, will be a collecting banker or a presenting bank, because they will present the check for payment to the paying bank. The banker who receives the check of another bank from the customer for collection and credit of the amount. Then this instrument in the original clearing setup used to travel to the clearing house, to the clearing branch, basically service branch of the HDFC Bank. Then from service bank it used to go to the clearing house. From the clearing house, these checks are sorted by machines, and then the check used to go to ICICI Bank physically, and physically ICICI Bank, it used to go to the service branch, from service branch to my branch which is there in Lower Parel, and then at Lower Parel they will verify my signature, check the details, etc., and then if balance is there and everything is fine, they will pay, and then they will advise. If it is not returned, then HDFC Bank is satisfied that the check is not returned, then they will credit Siva's account. So all this process is clearing. Now with check truncation coming into place, what is happening is the prima facie verification of genuineness of instrument, etc., is done at the presenting bank stage itself. If there are any material alterations, etc., whether the instrument is proper or not, all these primary details are checked by the presenting banker, and the instrument is kept with them. The image of the instrument is captured, and that image is passed to the clearing house and then to ICICI Bank. And ICICI Bank works basically on the image only. This is what is called check truncation. So the primary obligations of seeing material alteration, etc., and the apparent tenor of the instrument, whether there is any alteration, modification, etc., all this responsibility has now been put on the presenting or the collecting banker. Once that is passed, the paying banker is responsible in relation to the payment of the instrument. But if he is having any doubt relating to the instrument, he can call for the instrument, because ultimately he is going to pay for it. So this process is simplified. This clearing process is hastened, and more responsibility is cast on the presenting banker insofar as scrutiny of the instrument and the alterations, etc., is concerned. But the genuineness of instrument and all those other aspects relating to this, if they have any doubt, they can call for the paying banker can call for this the physical instrument. The banker who has to pay the amount of the check, that is ICICI Bank in this case, will be the paying banker. And pay in case Siva is presenting the check across the counter, then he will be anyhow the paying banker. Duty of the paying bank to see, he has to see whether the instrument is in writing. Then he has to see if the instrument is genuine. Now this genuineness, a washed instrument and etc., all this have to be seen at the collecting bankers level itself, presenting bankers level itself. Then instrument is in order and complete. Then the instrument is not post dated or stale. Then it has been signed by the drawer. The signature matching is something which a paying bank only has to do. And whether it is payable to bearer or order, that all these aspects have to be verified. And if the payee is a certain person, whether there is an unconditional order to pay, and if all these are met, whether balance is available or arrangements exist for honoring the check. That is, if balance is available, suppose there is 10,000 rupees and I have received a check of 15,000 rupees. So there is no balance in the account, but the account, probably the bank has given him a facility saying that I will accept subject to providing you an overdraft of another 10,000 rupees. So up to 20,000 rupees, they can honor the check, but the check is only of 10,000 rupees, 15,000 rupees. So they can honor the check based on the arrangement of the bank with the customer. If it is okay, then the check will be paid. If it is not, or if any of these things are missing, then the check will be returned along with the return memo. The responsibility is to exercise reasonable care and diligence. Then precautions that are supposed to be taken is to check the crossing, whether it is general or special, and whether it is coming from the bank from where it is supposed to be coming. Then branch, it is not relevant except if paid across the counter. Then form of the check, the standards are set by Reserve Bank of India. Then date of the check, it should not be post dated and stale. Stale means whose maturity is over. Now the check's maturity is 3 months. So beyond 3 months, it becomes a stale check and it should not be paid. Then account to be debited. Then amount in words and figures. If words and figures don't match, then the words will be taken into account and not figures for making payment. Then not mutilated. No material alteration other than permitted. The only material alterations that are permitted is striking out the bearer and revalidating the instrument so that it becomes. But they have to be done with authentication of the person. Then endorsement, whether there is any endorsement and whether it is valid. Then whether the account is not attached by any other authority, like a garnishee order or something like that, whether if there is or income tax attachment, etc. So whether there is any attachment order on that account, that has to be seen, and whether the account is on hold, whether it is whether the check has not been stopped. And in case of making payment or even for presenting, banking hours are supposed to be, it has to be done during banking hours. Then signature of drawer, whether it is matching or not, has to be checked. And whether sufficient balance or overdraft arrangements are there. So all these are supposed to be checked and ensured by the paying banker. Then only he will get statutory protection. He will get statutory protection only if payment is made in due course. That is, it is paid in accordance with the apparent tenor of the instrument. The payment is made in good faith and without negligence, and payment is made to the person entitled to receive payment. If these three things are done, then the payment is supposed to be in due course and the protection will be available for the paying banker. Then dishonor of check is a very important aspect, and this chapter 17 of the Act deals with the penalties in case of dishonor of certain checks for insufficiency of funds in the account. The sections that are dealing with this are section 138 to 149 of the Negotiable Instruments Act. So important amendments have been made in 2019, providing for an interim compensation pending decision. And second, where there is an appeal, pending decision of the appeal, a payment of interim compensation, appeal by the person who is defaulting in payment. So in that, if he is filing an appeal, then the payment pending appeal can be made. So basically, this is provided for enabling money to be received by the party. Okay. Then it is important to ensure protection and relief for beneficiary of a bounced check. And it also deters the penalty of imprisonment and the fine of twice the amount of instrument is a deterrent for persons who to issue from issuing checks without having sufficient balance in your account. So if you are going to have that, the trust on the financial system will be lost, and the trust on checks as an instrument of payment will be lost, and this will have an impact on the trade, financial system, etc. So that is the significance of this chapter. Then dishonor of check, section 138 is the operational section, which is very important. The offense of dishonor of check occurs when a check drawn by a person on an account with banker issued to another person in discharge of whole or part of a debt or liability. And this debt or liability has to be a legally enforceable debt or liability. If it is returned by the banker unpaid, and what is the reason for return? If the amount standing to the credit of the person is insufficient to pay the check, or the amount exceeds the amount arranged to be paid from the account by agreement with the bank. As I told you, an example, 20,000, 10,000 is my balance in my account. The bank agrees to provide me an overdraft facility up to 10,000 rupees. So if the amount of the check is 15,000 rupees, the bank, though it is not meeting the amount which is standing to the credit of my account, it is excess of that. But because there is an arrangement of 10,000 more, the bank will honor the instrument. But imagine that I give a check of 25,000, the balance is 10,000, the arrangement for overdraft is 10,000, so only up to 20,000 I can have. But I have given a check of more than 20,000, so this instrument has to be dishonored for not having sufficient balance in my account. And if this particular instrument is given to me, given by by me for satisfaction for discharge of a debt, either in whole or a part. So I go, I have taken a home loan. I am giving a check signed indicating this 25,000 rupees, but there is no balance, only 10,000. Arrangement is another 10,000. So this check, if it bounces, because it is meant to deal with my home loan liability, which is a legally enforceable debt, then I will be committing the offense of dishonor of check under section 138. What is the penalty? Punishment. Punishment is imprisonment up to 2 years and fine up to twice the amount of check, or I can have the best of both worlds. That is, I can be having imprisonment as well as fine. Then the prerequisite is the check is presented within a period of validity or 6 months, whichever is earlier. So earlier 6 months used to be the tenure. Now the validity is 3 months. Then other requirements for taking up this are the payee or holder gives a notice in writing demanding payment of the check. So it comes returned with a insufficient balance. I will get a I will get a memo from the bank along with the check. So on receipt of this, I will give a notice in writing to the person who is supposed to make the payment. The person who has issued me this check, I will say that why did your check got bounced? Now you pay me the amount. Okay. So this notice I have to give within 30 days of intimation of dishonor by the bank. And after I send this notice, within 15 days of receipt of the notice, if the drawer does not pay the amount, then the offense has been committed for me to take action. So the dishonor will be where I am not in a position to pay. After that is there, I will give a notice within 30 days, and from 15 days within the notice of demanding the payment on account of dishonor, which I got to know, even after that time, if he doesn't pay, then I will take legal action. What is the legal action? I will file a complaint in writing. And before whom should I file the complaint? I will file it before the Metropolitan Magistrate or First Class Judicial Magistrate. Where if the check is delivered for collection through an account, the bank and branch where the payee or holder in due course has an account, even if delivered for a collection at a bank or branch deemed to be delivered to the branch. Okay. If the check is presented for payment by payee or holder in due course, otherwise than through account. So I go to the branch and I collect the money and I am not paid. Then what I will do, at that particular place where the branch is located, I will do. Where the check is delivered for collection through an account. So I have my account here. So from here, the offense has happened here. I will file a complaint here. So the place where, say, if I'm, my brother is receiving this, say, Siva. I've given this check to Siva. So Siva approaches ICICI Bank, Lower Parel. So there he can, if it is dishonored, he will have to file a complaint there at the Metropolitan Magistrate having jurisdiction over Lower Parel area. The second thing is, if he is giving it for collection, say from Hyderabad, he can file it at Hyderabad, the bank and branch where the payee or holder in due course has an account. So he has a HDFC Bank account. He has presented it at Lakdi Kapul branch. Then he can file a complaint before the Metropolitan Magistrate having jurisdiction here. Okay. Then This complaint has to be filed within 1 month from the date of cause of action arising. The cause of action arising here is not the dishonor of check. So the dishonor of check has happened. I have given him a notice within 30 days. Then within 15 days of receipt of the notice, he doesn't pay me the money. Then cause of action arises, and from there, within 1 month, I will have to file a complaint. Then the trial could be a summary trial or a regular trial. Summary trial can be done where the court feels that the offense is such something where the imprisonment can be less than 1 year or fine can be up to 5,000 rupees, then they can do a summary trial. Otherwise, they will have to do it as a regular trial, recording the reasons in writing. Then the trial has to be held day after day till conclusion, unless necessary for reasons recorded in writing. So where it is not done on a day-to-day basis, they will have to record the reasons why it is not done. All intended to expedite, and the process is supposed to be completed within 6 months from the date of filing of the complaint. Then interim compensation is basically intended to provide some funds. So someone say that I have to give you a 10 lakh rupee instrument, but presently I don't have 10 lakhs. But a dishonor happens because you don't have 10 lakhs. So whatever money you have, some money I should be in a position to get back from you. So to enable that, the interim compensation provisions have been incorporated in case of a complaint, as well as in case of an appeal, where the dishonoring party raises the appeal. First, interim compensation. This was introduced in 2018. The court trying the offence may direct the drawer of the check by order to pay interim compensation to the complainant of not more than 20% of the check amount. So imagine this 25,000, say 1 lakh. The interim compensation that can be ordered is not more than 20,000 rupees. If the summary trial or summons case, he pleads not guilty, or in any other case, once the charge is framed that there has been a dishonor of account, then the court can order interim compensation to be paid by the drawer of the check. So the amount has to be, once the order is issued, the amount has to be paid within 60 days. And if he says that there are sufficient reasons, then the court may extend another 30 days. So if at the end of the proceeding trial, if the person is acquitted, that is, he is saying that you have not committed the offense, in which case whatever amount has been received by the person as interim compensation, he has to pay it back with interest at the bank rate. And what is the date of the reckoning the rate? The rate which is applicable at the beginning of the financial year of the trial of the order being issued. So imagine the time this amount has to be paid within 60 days, and if there is sufficient reason, 30 more days can be given. So if interim compensation is paid or recovered, not paid, then it can be recovered as if it is a fine under section 421 of CRPC. Then other aspects, presumption in favor of holder that check received is for discharge of debt or liability. It is for the other man to say that no, I don't owe anything to him, so it is not in discharge of a debt or liability. This is according to section 139. Then drawer saying that he had no reason to believe that the check will bound for funds, sufficiency of funds will not be allowed in his defense. That is, after issuing a check, he cannot say that I never expected that this money will not be there in my account. That defense will not do. When he is giving an instrument, he should be ensuring that there is balance. Tomorrow he cannot say that unless unfortunately kuch aur paise nikal gaya, I could not do because of that. He cannot bring any excuse like that to his defense. Then service of summons to accused or witness at place where he ordinarily resides or carries on business or personally works for gain. If it is done by speed post or courier approved by sessions court, it will be treated as served if an acknowledgement duly signed is received, or if the courier boy says that it was tried to be delivered but he refused and puts his signature. Either of these documents will be sufficient to prove that the summons have been served to the accused or witness. Then the evidence can also be taken on an affidavit, and if need be, that affidavit can be read out as submission in the court in trial. Otherwise, where there is any cross-examination or something to be done, they can be brought to the court and they can be examined physically also. Then bank slip or memo with an official mark denoting that the check has been dishonored is prima facie evidence of the fact of dishonor unless disproved. So any slip that is given of dishonor of the bank will be treated to be a valid evidence. If it is not valid, the other person has to prove that this is not a valid thing. Then offense is compoundable, that is, on payment of money, the liability can be wiped off. Then imagine that the decision is made and the money is supposed to be paid by the person. The fine is imposed or twice the amount of the instrument. Then he goes on an appeal. So the appellate court handling the appeal by drawer against conviction may direct the appellant by order to deposit a sum of minimum of 20% of fine or compensation awarded by a trial court. So imagine that I have given a check of 1 lakh and that 1 lakh check bounced. Then the court ordered me at the time of trial an interim compensation of say 20,000 rupees. So the 20,000 rupees is there. Now the trial is complete and I have been, the court held me guilty and they have issued an order saying that he has to pay 2 lakh rupees. So the moment I receive the order, I file an appeal before the appellate court. At the appellate court stage, they can indicate that I, as the person who is supposed to be receiving money, if I make an application and I say that I need interim compensation, payment pending appeal, then the court will examine it and they will ask the person who has filed the appeal to pay an amount not less than 20% of the amount. So the court has ordered, the lower court has ordered a compensation of 2 lakhs. So on application, the appellate court can say that 20% of 2 lakhs, that is minimum 40,000 of fine or compensation, they can be awarded. They can direct the appellant to pay to the payee or a beneficiary. So this is independent of the interim compensation awarded at the time of trial. The trial ke baad there is an order which is issued. I have not complied with it. I have taken it for appeal. So the 20% I have already kept there, 20,000 rupees. But this 20,000, now whatever 40,000 is independent of the 20,000. So this amount that is directed by the appellate court has to be paid within 60 days. And this amount, if I am not able to pay within 60 days, and if I indicate that for this reason I am not able to pay, the court can give me 30 more days. The amount may be released to the complainant at the time of, at any time during the pendency of the appeal. Suppose at the end of the appeal he is acquitted, then whatever amount that has been received has to be paid back with interest at bank rate, the rate which is there on the beginning day of the financial year when the decision has been issued. Then this amount has to be paid within 60 days from the date of the order, and this interim compensation paid or recovered, it is recovered as fine under section 421 of the CRPC. So then if an offense is committed by a firm, corporation, association, etc., who will be deemed guilty of the offense and who will be punished? So all the persons who are in charge of or responsible to the company, firm for the conduct of business of the company or the firm, it's not a corporate entity, but a company, corporation, they will also be held liable for the offense. Then any director, manager, secretary or other officer of the company with whose consent or connivance or with whose negligence. So if these are there, all these persons are also liable for the offense. Exception, if the person proves that the offense was committed without his knowledge or he exercised all his diligence to prevent commission of the offense, then that person will be not liable for compensation. The person who is nominated as a director of a company by virtue of holding his office or employment in the state government, central government or financial corporation. So basically he is a person who is nominated as a director. So that person will not be liable for prosecution. But every other director, person in charge of business will be liable. This is as far as the provisions relating to dishonor. So with this, we've completed a major portion of our dishonor, negotiable instruments. There is a lot of coverage. So in about 2 hours, I tried to cover whatever is necessary as far as these are important as far as these topics are concerned. Okay, thank you.